Good morning, everybody. Welcome to a special edition of Good Logic, where we will be presenting to you today, for your viewing enjoyment or displeasure, oral arguments before the D.C. Circuit Court. In the case of U.S. v. Trump, at least the one that's filed in Washington, D.C., this will be before the D.C. Circuit Court. We're going to spend the next few minutes discussing the judges who will be overseeing this proceeding. Now, it's still unclear who is going to have a chance to argue. I understand that John Sauer is going to be arguing for Trump. Expect Jack Clark himself to be arguing on behalf of the U.S. There were indications from the court that they're interested in hearing from persons who filed amici briefs. One of those briefs was filed by former Attorney General Edwin Meese. And it raises a collateral attack. When we say collateral attack, what I mean by collateral attack is that there's the issues that relate to the specific that relate specifically to the legitimacy as to whether or not there is basis for these charges. And the collateral attack that was raised by former Attorney General Edwin Meese, his brief, which is it's very unusual for a former attorney general to weigh in with an amici brief. He basically is saying, I'm not expressing any opinion on the legal legitimacy of these charges. I'm not weighing in about whether there's presidential immunity here or not, or where that extends. I'm weighing in about Jack Smith and this appointment as special prosecutor, and his appointment as special prosecutor that he's saying is unconstitutional. And that the process for creating this role and Jack Smith's conduct in this role is all unconstitutional, because he says that there's a special, that the issue as to what a special prosecutor is. It sounds like it's like a made-up term. The constitutional basis for whether or not a special prosecutor can ever be appointed, and if they are appointed, who has to appoint them, and the nature of that role in the structure of our government, whether it certainly has to be deemed an officer. The question is whether that's considered an inferior officer or a superior officer. And they point out that it makes almost no sense. He's joined by two other individuals who are considered legal constitutional scholars, and they say that it makes virtually no sense under any reading of the Constitution to label the role of the special prosecutor, who acts outside the scope of the Attorney General, as an inferior officer, because the nature of his capacity, given what the Constitution describes being a superior officers or inferior officers, and this is laid out expressly in the Articles of Constitution, it forces, if it's almost impossible to classify him as an inferior officer. And once he's classified as a superior officer, it's very clear that all superior officers, the Constitution is expressed, that the nature of how that appointment would come is that it would be someone who is nominated by the President of the United States, confirmed by the Senate, and then after they confirm it, there's an official appointment by the president. These are all steps. None of these steps happen with respect to Jack Smith. Instead, Merrick Garland came along and basically said, I hereby make you special prosecutor, which it's hard to understand any constitutional basis for him to have that authority to pass that on to someone else, to pass those incredibly broad, sweeping powers onto a third party. Because he just doesn't have the authority to do that. And in that case, that none of the charges that were brought by Jack Smith are constitutional, that they all must be dismissed. So that's what Edwin Meese's point is. And I think it's a really interesting, so we call that a collateral attack. Because what he's essentially saying is, should Trump be charged? Maybe. That's what Edwin Meese's position is. Maybe. Is he guilty? Maybe. I don't know. I'm simply saying this has to be dismissed because the guy who brought it, and the nature of this office is unconstitutional, and that cannot be allowed to stand. It's a very interesting argument, which it seemed there's implications that the court is going to be willing to entertain that and perhaps hear oral argument on those issues. So I'm very curious to see how that goes as well. I would anticipate that the structure is going to be that normally the movement, the petitioner, who in this case is the defendant, is the first to speak, followed up by the respondent. So the respondent, the appellee, maybe appellant versus appellee, or appellant versus respondent, depending on the nature of that's just a nomenclature distinction. There's no difference really. But normally the loser is the one who talks. The one who's looking to have the lower court's decision overturned is the one who talks first. They will likely spell out how much time each of them are going to have. Now let's look at this panel of judges as to who is going to be weighing in here. And I pulled this up here. All right, where are you? So the three judges are Judges J. Michelle Childs, Florence Pan, and Karen LaCraft Henderson. Three judges. In fact, I want to pull up a bio on each of them. Let me pull this up here. So give me a moment. I got a little bio for each of these judges. The first two were appointed by Biden. The third one was appointed by, as much as conservative, was appointed by George Herbert Walker Bush. So she's a little long in the tooth. I do not expect us to have video. They're supposed to be simply an audio feed. So let me share this with you. There is Judge J. Michelle Childs. Juliana Michelle Childs is her name. And apparently, so she served as U.S. District Court from the District of South Carolina from 2010 to 2022, as a state court judge in South Carolina from 2006 to 2010. And she was first nominated by Barack Obama to serve in the U.S. District Court. Frankly, what you would expect to get in D.C. D.C. is the pool of people who are in D.C. is going to be very strongly left-leaning. I would anticipate that if Trump loses at this level, which I would not be at all surprised to see him lose at this level, especially given his... But that is Judge Juliana Michelle Childs. The next person I mentioned to you, who was also appointed by... sorry about that. Who was also appointed by Biden to the D.C. Circuit Court, is Judge Florence Pan. Let's see if we pull her up here. What we got? And she's fresh out of the womb on the Circuit Court. This is Judge Pan. So she's born 1966. Previously served as U.S. District Judge, U.S. District Court for D.C. from 2021 to 2022. Wow. Okay. Oh, so she was a Superior Court judge for D.C., which is not. That's essentially because D.C. is working when you're working in D.C., so it's a federal district. So all the judges there have to be appointed by the president. So she first was brought in by Barack Obama, and she's been bouncing up the chain ever. And she first became a district court judge, the District of Columbia, in March of 2021. And merely a year later, Joe Biden gave her a nice little promotion to the circuit court. Yeah, this is not a good judge for her. This is not going to be a good judge. He bumped her up two steps in the last 3 years. This is not going to be a good judge for Trump. That is not going to be pretty. That's not going to be pretty. Judge Florence Pan. The third judge here, the one who was appointed by George Herbert Walker Bush. It's 9:26. It's Karen Kraft Henderson. Let's pull her up here. Got a little feel for Karen Kraft Henderson, the third on this panel of D.C. Circuit Court judges. Oh, yeah, she's 75. More than that. Excuse me. She's almost 80. Karen Kraft Henderson, born 1944. Serving as a federal judge from 1986, and then raised up to the circuit court in 1990 by George Herbert Walker Bush. Well, given the pedigree of these judges, you would expect this to be 2-1. Let's face facts. Be interesting to see if it falls along those lines. Karen Henderson here seems to be fairly right-leaning. You would expect it to be 2-1 against Trump. Now, I will tell you that it's likely that if Trump loses, he will request a rehearing en banc, which means that I want the entire panel of D.C. Circuit Court judges, which is roughly a dozen or 15, to hear arguments and issue an appearance and issue their decision. You're not entitled to, they can't compel it. It's likely it would be granted the opportunity to be heard en banc because these judges like being able to weigh in on political matters. Anyhow, that's what we got going on here. That is what we got going on here. I want to, I'm going to start switching over so that we can have everything queued up and ready to go. Queued up and ready to go when this thing is supposed to start rolling at 9:30. But I just want to give you a little overview as to what we should be expecting and also what the story is with respect to how the structure works, what arguments are going to be presented, and who's overseeing this. So now we covered all of that. This is supposed to start in 1 minute and 11 seconds. They even have a nice little counter time. They even have a timer counting down here. If you have any questions, feel free, weigh in. I would appreciate if you're here, if you could like and subscribe. That would be cool of you. This is oral argument. Supposed to be starting up in 50 seconds. Chat's disabled for this line. This is the United States Court of Appeals with the D.C. Circuit Court. But I would anticipate that whoever loses is ultimately going to move to get before the court. Why is this not? Let me make sure that this is still rolling here. Okay, we're good. They didn't even let me make this a full screen. That's so weird. I can't make this full screen. Gah! That's not what I wanted. This is weird. PowerPoint expand. Sorry, I'm trying to figure out why this is looking so funky. I've never seen this. This is an appeal for U.S. versus Trump in the District of Columbia, D.C. Circuit Court. And yeah, apparently they're later than I was. I was smack dab on time today. There's not going to be any video. This is purely going to be audio. I'm not anticipating any video at all. So There we go. Seems like something's happening. You guys can hear it, right? I mean, there's no one talking now.
Oh yay, oh yay, oh yay. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3228, United States of America versus Donald J. Trump, appellant. Mr. Sauer for the appellant, Mr. Pierce for the appellate.
Sauer, good morning. Before you get started, can I just get a couple of things on the record? Our jurisdiction was challenged by an amicus, but from your reply brief, you are not questioning our collateral order jurisdiction.
Correct. We defend the collateral order jurisdiction. That's correct, Your Honor.
And then also, you have either abandoned or not made the Fifth Amendment double jeopardy argument before us.
We have framed the double jeopardy argument as arising principally from the impeachment judgment clause. So we haven't argued that if you go straight to the double jeopardy clause, that alone would result in reversal. We're focusing on the impeachment judgment clause. Now that incorporates principles of double jeopardy, right, but we haven't said a straightforward directly under the double jeopardy clause in this court at this time.
Go ahead, then.
Well, before that occurs, then I do want to speak to you a little bit more about jurisdiction, because we still have to satisfy ourselves that we have the jurisdiction. So even though you believe that there's interlocutory jurisdiction with respect to the collateral order doctrine, how do you place that in line with Midland's asphalt case, which specifically says in a criminal case, your jurisdiction needs to stem from the Constitution or be explicit as well in statutory law?
We have three responses to that, if I may, Your Honor. One is, of course, that if you look at the language of Midland asphalt, what Justice Scalia is discussing in that case is particularly right, a situation where the right is one, the legal and practical value of which would be destroyed if it were not violated before trial. And these claims of absolute immunity fall right in the heartland of that description of that right. That's been reinforced by the Supreme Court.
But how do you deal with explicitly stating that? Because we don't have an explicit communication here with respect to anything in the Constitution or statute.
Yeah, I respectfully disagree with that. The doctrine of presidential immunity arises directly from Article 2, Section 1 in the Executive Vesting Clause. And it's reinforced by the plain language of the Impeachment Judgment Clause, which specifically refers to trial. Remember, what Midland asphalt is talking about is situations where the right not to be tried is at stake, and it distinguishes that from the right, the remedy for which is the dismissal of an indictment. So when you're talking about the right not to be tried, we have the clearest and most explicit reference to trial of any of the clauses in which the Supreme Court has found interlocutory jurisdiction.
But there have been other circuits that have indicated on the issue of immunity, Midland asphalt still applies.
Yeah, not presidential immunity with respect to this court.
That's what you're making your distinction.
Right. And well, what I would say is this court's decision in Cisneros explicitly says, right there, and it says most separation of powers claims may not be subject to interlocutory review, but there are some that may. And then it goes on to say presidential immunity arising from the separation of powers, citing Clinton against Jones. So Cisneros, I think, expressly contemplates that there be interlocutory jurisdiction in this sort of claim. And that's further reinforced by the court's subsequent decisions in Rose and Rostentowski situations where the court said, look, there's a speech and debate claim, and there's also another claim it isn't derived directly from the Constitution, but it's closely akin or analogous to such a claim.
Again, about explicit, because in the double jeopardy trial scenario, you have twice put in jeopardy. So you cannot be tried again in that regard.
That sounds like
Again, in the speech and debate, it says shall not be questioned. So the language was explicit, but you're not giving me anything that says explicitly in the references that you cite.
I have two responses to that. One is the plain language of the impeachment judgment clause, which says that only the party convicted shall be subject to indictment, trial, judgment, and punishment according to law.
But so that's if you take the negative inference, correct?
That's the plain language supports that we've heard from the very beginning that it is the natural and ordinary meaning. The impeachment judgment clause. So that is an argument that is explicit. And I also point out that this court in Rose, in Rostentowski, in Cisneros, expressly held this is not a magic words requirement. In other words, it isn't that it's got to say right there in the text of the Constitution or a statute that this is a right not to be tried. It's that the right once formulated has to explicitly include the right not to be tried. And that's why what actually the language that's previously in Midland Asphalt is heavily emphasized by Justice Scalia is the situation where there's interlocutory appeal when it's a right, the legal and practical value of which is destroyed if it's not vindicated before trial. There's similar language in Cisneros. And for all these, I'd also point out the government also has not challenged the court's jurisdiction. It has conceded.
We have to be
absolutely
secured in our own jurisdiction.
Yeah.
Has the Supreme Court itself referred to the Midland Asphalt as a suggestion?
I'm not aware of that, but I think
in digital equipment.
Gotcha. Yes, Your Honor. I believe Your Honor is correct about that. I think that's an excellent point, and that's reinforced by this court's case law in Cisneros, Rose, and Restantowski. Turning to the merits, if I may, Your Honor. To authorize the prosecution of a president for his official acts would open a Pandora's box from which this nation may never recover. Could George W. Bush be prosecuted for obstruction of an official proceeding for allegedly giving false information to Congress to induce the nation to go to war in Iraq under false pretenses?
Theoretically.
Could President Obama be potentially charged with murder for allegedly authorizing drone strikes targeting U.S. citizens located abroad? Could President...
So can I explore sort of the implications of what you're arguing? I understand your position to be that a president is immune from criminal prosecution for any official act that he takes as president, even if that action is taken for an unlawful or unconstitutional purpose. Is that correct?
With an important exception, which is that if the president is impeached and convicted by the United States Senate in a, proceeding that reflects, widespread political consensus, that would authorize the prosecution under the plain language of the impeachment judgment clause. So yes, with that exception.
So it seems to me that there are a lot of things that might not go through that process because it's quite a cumbersome process that requires the action of a whole branch of government that has a lot of different people involved. And so in your view, could a president sell pardons or sell military secrets? Those are official acts, right? It's an official act to grant a pardon. It's an official act to communicate with a foreign government. And such a president would not be subject to criminal prosecution?
The sale of pardons example is an excellent example because there were allegations about a sale of a pardon, essentially when it came to President Clinton's pardon of Mark Rich, and the U.S. DOJ carefully, and for the very reasons we've emphasized in our brief, decided not to prosecute President Clinton with that because it raised concerns about whether or not a president can be prosecuted for his official acts. There's actually an op-ed in the National Review from Andrew McCarthy.
But your position is that he can't be prosecuted for that unless he's impeached.
Yeah, that was, as long as it's an official act. I mean, certain cases, purely private conduct under Clinton against Jones, he'd be subject to prosecution for that as long as he's not in office. But as long as it's official act.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to seal Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not...
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
No.
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There is a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders are much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts.
Yeah.
And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted? And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first. We may be saying the same thing.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons could sell military secrets, could order SEAL Team 6 to assassinate a political
We'll come
rival.
back to this later.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not prosecuted.
But your brief
So-
says that communicating with an executive branch agency is an official act, and communicating with a foreign government is an official act. That's what presidents do.
They're very strong situated. Those are very strong examples of potential official acts. If you look at what Chief Justice Marshall said against Madison, he said, rising directly under Article 2, Section 1, that the courts, that the president's official acts are, quote, never examinable by the courts. And he says it like 4 different times on pages 164 to 166.
So let me ask you about that then, counsel, because your position is, as I understand it, if a president is impeached and convicted by Congress, then he is subject to criminal prosecution, correct?
Yes.
That would be a necessary, said to prosecution.
Is that a yes?
Yes. Yes.
Okay, so therefore, he's not completely and absolutely immune, because under the procedure that you concede, he can be prosecuted if there's an impeachment and conviction by the Senate.
Very, very formidable structural check
That's
against the
child.
astonishing radical action of prosecuting a former president with official acts.
Correct, but you're conceding that presidents can be criminally prosecuted under certain circumstances.
Specifically, if they're impeached and convicted, I think that's the plain language of the impeachment judgment clause.
And isn't that also a concession that a president can be criminally prosecuted for an official act? Because presidents can be impeached for official acts.
Under those unique circumstances.
Correct, but given that you're
President.
conceding that presidents can be criminally prosecuted under certain circumstances, doesn't that narrow the issues before us to, can a president be impeached? Can a president be prosecuted without first being impeached and convicted? All of your other arguments seem to fall away. Your separation of powers arguments fall away. Your policy arguments fall away if you concede that a president can be criminally prosecuted under some circumstances.
Disagree with that. The Constitution in the Article 2, Section 1 vesting clause, as interpreted very clearly by Chief Justice Marshall and Marbury against Madison, says Article 3 courts lack jurisdiction to engage in examination of the president's official acts. That's
But
been
you just
reaffirmed by
conceded that Article 3 courts can do so if he's been impeached and convicted.
the Constitution makes a carefully balanced,
That's the only
explicit
time.
exception to that principle in the impeachment judgment clause.
Yeah, that's the
So
only time.
the problem for the separation of powers, the Constitution does this in many other situations where it engages in a balancing. What the framers were most concerned about was not the notion that the president would never be prosecuted for things that outrage his political opponents. What they were concerned about was politically motivated prosecutions. But they didn't say the president can never be prosecuted. They set up the
Correct.
separation of powers and they created a very narrow exception
Correct,
that would
but-
allow prosecution in those cases.
But once you concede that there's not this absolute immunity, that the judiciary can hear criminal prosecutions
Condition precedent.
under any
Get
circumstances,
convicted at
you're
impeachment
saying there's
first.
one specific circumstance,
Say condition.
then that means that there isn't this absolute immunity that you claim.
I'm not aware of any case or constitutional doctrine that would say the Constitution sets up a very strong principle and it creates a very narrow exception, and therefore the exception just makes the principle vanish. I just disagree.
That's
with
not what I'm
That is what you're saying.
asking you.
That is what you're saying.
I'm saying that you're
Kyle.
coming before us and saying that there is this absolute immunity that is grounded in the separation of powers, that the judiciary can never
Precedent.
sit in judgment on what the president is doing. But
Like,
you're conceding that that's not true because under some circumstances, the judiciary can do that. That's all I'm saying.
I think I repeat my answer, which is that there's a very strong principle in the separation of powers that prohibits Article 3 courts from sitting in judgment over a president's official acts.
wow.
There's a very narrow exception for conviction after
I
impeachment.
understand, I
And
understand.
that's
But
the position.
it just seems to me that if once you concede that presidents can be prosecuted under some circumstances, your separation of powers argument falls away. And the issues before us are narrowed to, are you correct in your interpretation of the impeachment judgment clause? Does the impeachment judgment clause actually say what you say it says. That's all that's really we need to decide.
No.
I respectfully disagree with that. I respectfully disagree with that. There is a strong principle. It's reinforced by Chief Justice Marshall in Marbury against Madison. He did not say we can never sit in judgment over a president's official acts, but because it can be impeached, convicted, therefore we can do it whenever we want to. He said the exact opposite. He says they are never examinable by the courts.
So
And
are
that's
we answering the larger question about whether there's presidential immunity from criminal prosecution for official acts, or are we looking to a standard on a motion to dismiss, which says, look to the allegations, take those as true, and then look to whether or not we should be looking at official acts in that lens?
actually both threshold question based district court judgment is essentially there's no such thing as criminal immunity for a former president, and therefore the district court never reached the second issue, which is if you actually look at the face of the indictment, are these all official acts? We have strong arguments on both of those things. The notion that criminal immunity for a president doesn't exist is a shocking holding. It would authorize, for example, the indictment of President Biden in the Western District of Texas after he leaves office for mismanaging the border allegedly, and let a Texas jury and Texas judge sit in judgment over the validity of his acts.
Also indicated earlier that when there were pardons or when people were not prosecuted, not everybody goes through an impeachment proceeding before they actually get prosecuted, because that's within the discretion of the prosecutor.
Only for subordinate officers. So as the OLC memo points out very clearly, the framers actually in the Constitutional Convention clearly contemplated that that sequence that I've described would be mandatory. He would have to be impeached and convicted first before you could go on
but
to.
Impeachment also only deals with certain crimes. Bribery, treason, high crimes and misdemeanors.
Yeah, and if you look actually at what is said in the Federalist number 65 by Hamilton about that, high crimes and misdemeanors basically cover anything that the U.S. Senate makes a political judgment justifies removing him from office and authorizing
But a
prosecution.
prosecutor is impartial, does not make political judgments, assumingly, to charge.
I think that has no basis in the context of the current prosecution, where the current incumbent of the presidency is prosecuting his number one political opponent and his greatest electoral threat in this particular.
I'm asking you from the standpoint of what the impeachment judgment clause is designed to do, that it limits itself to certain.
No, just the opposite.
acts.
It's supposed to protect
And
him.
then therefore, and if convicted, as you indicated, impeached and convicted, thereafter could be a prosecution. But not everybody goes through that process. And of course, it's limited to the certain actors in that regard, but not everybody has to go through that process. Prosecutors later on can come into information and evidence after they've investigated to make their determinations about what they'd like to criminally prosecute. So you're not always confined to whatever would be in the impeachment judgment clause.
Whatever the practice has been with respect to subordinate officers, the evidence from the founding generation is clear as you cannot do that with respect to the president. Right? And this is one example of many that's reinforcing all the Supreme Court's case law, the uniqueness of the presidency and the person who occupies the office of the presidency. So, for example, you get repeated statements in Nixon against Fitzgerald, it's reaffirmed in Trump against Mazars, reaffirmed in Trump against Vance, and so forth about the unique nature of that particular office.
But
and therefore,
even under Clinton, where there's a deal cut, under President Nixon, where there's pardon given, there's an assumption that you could be prosecuted, because why enter into those particular acts?
those examples are examples of purely private conduct. For example, Clinton against Jones makes very clear that the stuff that President Clinton cut an indictment deal about by admitting to certain wrongdoing in exchange for not being indicted was purely private conduct. Nobody has contended that the president's immune from prosecution for purely private conduct. It's a question is, can he be indicted for official acts? And you referred to the pardon of President Nixon. We have two things to say about that. President Nixon was accused of a wide range of purely private conduct. He was facing potential indictment for that at the time the pardon was issued.
Back to purely private conduct. If we go to the indictment, they are not alleging purely, they're alleging that this is private conduct, but it's subject to fraud, not official acts. So why don't you speak to that, since you said that we have to look at the broader question as well as the indictment?
Yes, Your Honor. So the allegations of the indictment allege only official acts. The only way to even characterize them as private acts is to turn to the alleged motive or purpose for them. So their whole theory, their characterization of the language in the indictment is, oh, we're alleging purely private conduct because it was engaged in for particular purposes. And that's foreclosed by a very long and strong line of Supreme Court precedents.
How does the Blasting Game case fit here, that this circuit distinguish office seeker versus office holder in terms of how you're committing the acts?
This Blasingame strongly reinforces what was said. It's been said in Supreme Court cases in Stump against Sparkman, going back to, for example, Marbury against Madison, where it's the nature of the act itself. I understand the Blasingame opinion to reinforce that by saying it's an objective. They use the word objective multiple times. Objective, context-specific assessment. It does not turn on the purpose or motive. That was strongly pushed in Blasingame, and this court properly rejected. That's consistent with Nixon against Fitzgerald, Bradley against Fisher, Spalding against Vilas, Judge Hand's opinion in Gregoire. I mean, that's the strongest principle of law in this context.
I'll turn to my colleagues because I've taken up your time, but we'll give you what you need. With respect to the actual indictment, it does not gloss over what, and put it in terms as you're describing. So if we look at the face of the indictment as to what's charged, when it's gone through a grand jury process,
purposeful,
unlike the impeachment judgment clause, how do we look at those particular acts as described? Because we have to take those at face value.
There's clear guidance on this from Nixon against Fitzgerald, where Nixon against Fitzgerald, the allegation was President Nixon had unlawfully terminated a whistleblower, essentially. And that whistleblower came into court and says, this is not subject to immunity because it was unlawful. And the court said, we're not looking at that granular level of detail, and we're not considering, most importantly, the alleged motive for these acts. It said that the level of specificity to consider it is conducting the business of the Air Force. Similar here, if you look at the indictment, there's 5 classes of conduct that are alleged, many of which are just obviously official conduct. Meeting with the U.S. Department of Justice about who should be the cabinet level officer running that. Is it the heartland of the appointments power?
You said many of which, so not
really all of which. I mean, Arcanich is all which. There's one exception because there's allegations about the ELIB speech, and under Blasingame, the contention was made that they should be remanded for that. But if you look at the other public statements, for example, President Trump's tweets, the Second Circuit held in Knight First Amendment Center that it was based on overwhelming evidence. That's an official channel. His Twitter account during the presidency was an official channel of government communication. And under the objective test in Blasingame, all those tweets are obviously immune. So also with meetings with the Department of Justice, meeting with members of Congress, that falls right within the heartland of Article 2, Section 3, which authorized the president to communicate with Congress about the matters that he views as expedient.
Let me ask you, first of all, I don't believe you were counsel then, but what about the 2 concessions made in the first impeachment proceeding and then in Trump v. Vance, that impeachment should be stayed and wait until he's out of office when he would be subject to criminal liability?
As to Trump against Vance, it was a purely private conduct that involved a subpoena, a criminal subpoena for tax records that long predated President Trump's time in office. So it was purely private conduct. The concession that he could be subject to prosecution is also correct. As for the impeachment brief, for example, that they've cited in their briefs, what that says is we have a judicial process in this country, period. We have an investigative process in this country to which no former officer is immune. It did not say there could never be raised an immunity defense. It said criminal process can go forward.
There's a quote in the congressional record in which your client said through counsel, no former office holder is immune from investigation and prosecution.
Investigation is what there's no immunity to. Well, that may be true of subordinate officers, but as to the principal officer, the president, he is immune unless he is impeached and convicted. Again, it comes back to the point
he was president at the time, and his position was that no former office holder is immune. And in fact, the argument was there's no need to vote for impeachment because we have this backstop, which is criminal prosecution. And it seems that many senators relied on that in voting to acquit.
Realizing speculation, said I think statement. What I think the court, I think, lacks the ability to intuit what motivated senators' votes in the impeachment process. What the Constitution says is you must be impeached.
I think the question that Judge Henderson was asking you was: you took the position, or your client did, during the impeachment proceedings, that there would be an option for criminal prosecution later, and it's in the congressional record. And I guess the question is, what has changed, or why have you changed your position?
To agree with that characterization of the statements in the congressional record, I believe there was a distinction between the judicial process and the investigative process. That was in the quote that I just read. In addition to that, whatever concession may or may not have been made there would not have a res judicata effect in this proceeding. These are very different proceedings. And again, the notion that no one is immune from the judicial process, and the judicial process should go forward, is fully consistent with the notion that defenses, including presidential immunity, which again is rooted in the separation of powers, we could be raised in those processes. So the notion that there could be a criminal process and then defenses like this could be raised in that process is I think, pretty straightforward. There's no concession that there's no such thing as criminal immunity. There's no concession in those proceedings that what the district court in this case did, the very kind of astonishing holding that no president is criminally immune from prosecution is just, I think it's not there in the congressional record.
Let me go back to Marbury versus Madison. And
That's
you
not a great argument.
isolated that one sentence. Isn't it true that the progeny of Marbury versus Madison has distinguished between discretionary official acts and ministerial, by which they mean imposed by law? And that it's the latter one in which he can be held
I raised my
liable.
volume.
And I want you to address
Still too low?
both U.S. v. Johnson and the Commonwealth of Virginia, because the first one deals with the speech and debate clause. And the Supreme Court said, in essence, lop off all of the evidence dealing with the speech and debate. He can still be prosecuted, that is, that congressman, for, I think it was conspiracy to defraud the U.S. or something. And then in the Commonwealth of Virginia, you had the judge.
I raised my volume again.
Who had been charged with a crime under which you could not discriminate in picking juries based on race. And my reading of that case is that the language that you isolate in your reply brief, that it could just as easily be done, that is the choosing of the jury, a ministerial act by someone on the street. To me, that means when you have a duty that is imposed by law, picking a jury, they said was ministerial, imposed by law. Whether you're the man on the street, whether you're the president, whether in that case you're the judge, you can be held criminally liable. And that's how I read, if not Marbury, the progeny. That is, you can't stop at official act. You have to say, was it a discretionary official act or was it a ministerial?
I agree with that characterization of Marbury. I think that distinction is present in Marbury itself. And I think what I would respond to that is to say, first of all, that extension has never been extended up to the president, and for good reason, because for over 200 years, the courts have held we can't sit in judgment over the president's official acts under any circumstances. So, for example, Mississippi against Johnson.
We don't have any criminal.
That's correct. It's never arisen until this case. That is absolutely correct. But if you look at every civil context, what they've said, you keep in mind that what Chief Justice Marshall says is never examinable. Never examinable. So there would be no judicial proceeding where you could say the president did this and we're going to sit in judgment directly over that. That's reinforced by Mississippi against Johnson, by Swan against Clinton from this court more recently, where the courts hold that we can't even enjoin or even really enter a declaratory judgment directly against the president for his official acts. Whereas the distinction between ministerial and discretionary has been held totally with respect to subordinate officers, and that goes all the way back to Marbury. However, if you look at the indictment in this case, nothing that's alleged against President Trump could remotely be described as ministerial. I'm not aware the government has ever argued that. If you're talking about, responding to widespread allegations of fraud, abuse, and misfeasance in a presidential election, trying to find how to respond to that in a manner that's in the national interest, matters of that nature are not ministerial at all. So even if that distinction goes all the way up to the, so to speak, it wouldn't save the indictment here.
Why isn't it ministerial when his constitutional duty to take care that the laws be faithfully executed requires him to follow those laws, every one of them?
Yeah, nothing. I would say that the take care clause, carrying out one's duties in the take care clause, are inherently discretionary. An example of a ministerial act, for example, in Marbury against Madison is like delivering a seal when you're requested, because there's a separate statute, right? What they emphasize is there's a separate statute. The Secretary of State had kind of these two hats on. He was, on one hand, a direct agent of the president in that could never be examined by the courts. On the other hand, the original statute had imposed all these like purely ministerial duties that had to do with record keeping and delivering documents. Like if you got a land deed that's got a seal on it and the person asks for it, where there's no discretion at all. When you're talking about the take care clause, there's no statute that could impose on the president a mandatory duty to engage. I mean, the notion that when the president's meeting with the Department of Justice, for example, saying, hey, we should investigate and enforce federal fraud statutes, the notion that that's ministerial strikes me as insupportable.
By their argument, Biden could be convicted for how he's handling the border.
What I'm asking, which is, I think it's paradoxical to say that his constitutional duty to take care that the laws be faithfully executed allows him to violate criminal laws. Now, we're at the motion to dismiss stage. The government has charged the specific criminal laws. We have to assume they're true.
I mean, my response to that, I think, would be to emphasize what Chief Justice Marshall said in Marbury, which is that they can never be examined by courts. That naturally includes a criminal proceeding.
But I thought you agreed with me that we've gotten beyond Marbury in the sense that official acts has been subdivided into discretionary and duty-bound or ministerial. And in the ministerial or duty-bound, at least with respect to even legislators and judges, they have been.
They're at a different standard. You can't compare a judge or Congress to the president.
And that's in the face, at least with respect to the legislators, of an explicit constitutional privilege.
Yeah, I don't view United States against Johnson and even ex parte Virginia as resting on the ministerial versus discretionary distinction. I think what Johnson says is, it doesn't say, hey, when you were doing these other things, they were ministerial. What it says is these were not legislative acts. Right. And so it draws a distinction between legislative and non-legislative acts. So also, I think that's the right reading of ex parte Virginia. They go on to say judicial act. In other words, the argument that picking a jury, I don't even believe they use the words, my recollection, ministerial. They say that
because they were criminal acts. They were criminal acts. Picking the jury based on race is a criminal act. And whatever Johnson did, I think it was the very same statute, fraud against the United States, that is before us today.
I would say that the distinction in those cases is between, in the judicial case, Johnson, the legislative case, Johnson, is between legislative acts and non-legislative acts. The distinction in ex parte Virginia is between judicial acts and non-judicial acts. That phrase is used. And here, the distinction is between presidential acts and non-presidential acts, and everything that's alleged in the indictment is a presidential act. Your Honor, I see.
May I? There are a number of precedents or cases in which the Supreme Court has reviewed actions by the president. The seminal case of Youngstown Sheet and Tube, where the Supreme Court reviewed Harry Truman's seizure of the steel mills during the Korean War. There's also the case of Little versus Bareem, where Chief Justice Marshall reviewed the actions of President Adams when he seized certain vessels. Trump versus Hawaii was reviewing President Trump's order restricting the entry into the United States of nationals from certain foreign
That's not
countries.
him standing in judgment.
How does that square with your position that the judiciary can never review executive action?
All those cases fall squarely within the well-established exception in ex parte Young, where the judiciary is allowed and does frequently issue declaratory judgments, injunctions, judgments against subordinate officers.
These are presidents. Harry Truman was the president when he seized the steel mill.
But it wasn't coming at him personally for seizing it.
In that case, was an injunction against the Secretary of Congress, not against the president. This court has reaffirmed very recently that you cannot issue an injunction directly against the president. The court has no jurisdiction to do that. Cannot enter. It strongly indicates in Newdow against Roberts that the court can't even enter a declaratory judgment.
The court can review presidential action if, on paper, they direct their judgment to a subordinate officer. Is that what you're saying? Because these are presidential actions.
The court can definitely enjoin the actions of subordinate officers that violate the Constitution. That is ex parte Young. All the cases fall within.
I'm asking you a different question because these are presidential decisions, presidential actions. And you're saying that the court can review presidential actions as long as when they issue the judgment, they issue it to a subordinate.
indirect context. It
You
can't directly
understand why
sit
we
judgment
have
over
the
the its
impeachment
official
clause?
acts. It's been established for over 200 years.
You're using the impeachment judgment clause essentially as a negative implication with respect to that the civilian officer or president, of course, has to be impeached and convicted, and then nevertheless thereafter. If there is an acquittal, how are you using it in that regard? Because sometimes, and particularly in this case, the acquittal can arise from lack of jurisdiction, not actually trying the merits of the case.
The impeachment judgment clause doesn't distinguish between those sort of merits-related acquittals and non-merits-related acquittals. Frankly, the same sort of thing comes up in just criminal prosecutions under the double jeopardy clause, where a determination that the defendant is acquitted does not necessarily reflect an actual determination that they're not factually guilty. And in fact, this is emphasized in the OLC memo that they themselves address, that actually, that determination often reflects things that are distinct from the merits. So that doesn't, I think, in any way undermine the sort of double jeopardy force, so to speak, of the impeachment judgment clause.
And one of the briefs indicated that Jack Smith is improperly appointed. Do you have a position there?
It's a very persuasive brief, but I can see we have not raised it in this case. I think it raises very powerful questions, but we haven't raised it in this case at this time.
Just about the effect of blasting game. If we say we can't determine if these acts are official or private, I want to stay away from that. I'm going to say ministerial or discretionary.
Her mic is kind of messed up.
And blasting game characterizes it in terms of office seeker versus office holder. What is your position about, would we have to remand it for the district judge to decide in the first instance whether these the 4 points that the defense has made against imposing criminal liability hinge on whether the acts are ministerial, discretionary, official, private, however you want to characterize it?
I used the phrase from Clinton against Jones, which says purely private conduct is what can be, subject to judicial process after a president leaves office. In response to your question, our principal position is you can look at this indictment and it alleges official acts and it can be ordered to be dismissed. We acknowledge, though, that the district court didn't reach that issue, but Blasingame did remand, and the court absolutely has the discretion to remand to the district court for the application of the doctrine of criminal immunity in the first instance. And we admit that that would be a natural thing for the court to do.
To the specific acts.
Correct. Yeah. In other words, if the court holds that there is presidential immunity, which it should, then remand to the district court to say, okay, go through the indictment or else hold factual findings and so forth to decide how it applies to the conduct alleged in this case. We acknowledge that would be, the court has the discretion to do that, and that would be a natural course. And if there are no further questions.
He's giving a little ground here.
I have one more question.
Saying go
so
act
under
by
the
act
framework
and see whether it's private act or not.
Were discussed in Nixon versus Fitzgerald. We're supposed to conduct a balancing test where we balance the need for the asserted immunity versus other public interests. And I see you as trying to represent a need for the executive to have this immunity to facilitate executive functions, the ability to act without hesitation, to be fearless, to make decisions without being inhibited by the fear of criminal prosecution. But it seems to me that there are some other Article 2 interests here that are countervailing. For example, under Article 2, there's an executive vesting clause. And so there is an interest of the executive branch as an institution to have constitutional executive power vest in a newly elected president. There's also an executive interest as an institution in law enforcement, in enforcing criminal laws. And so it seems to me, if we're weighing executive interests versus public interests, public interests in things like the integrity of an election, that President Trump's position is not fully aligned with the institutional interests of the executive branch. And in this balancing test, that weakens the executive power that he's trying to assert.
I say three things in response to that. First of all, Nixon against Fitzgerald emphasizes that the most compelling consideration when one considers what it describes as policy considerations rooted in or in the separation of powers is the rendering of the executive branch official unduly cautious in the exercise of highly controversial and sensitive decisions that come up all the time. If a president has to look over his shoulder or her shoulder every time he or she has to make a controversial decision and worry, after I leave office, am I going to jail for this? When my political opponents take power, that inevitably dampens the ability of the president.
No, I understand that that's your position, but I guess I'm asking you, what about other Article 2 interests? That's one interest, but there are other Article 2 interests in play here too.
Yeah, but Nixon versus Fitzgerald says you're wrong.
The interest in executive vesting.
You can decide that.
The interest in law enforcement. Those are also executive branch interests. And how should that affect the analysis?
Those, to the extent the court conducts a balancing our principal positions, you can go back to Marbury versus Madison and adopt a categorical rule, which is also referenced in Nixon against Fitzgerald. But to the extent the court reaches the balancing of policy considerations, those are decisively outweighed by the sort of republic shattering consequences of subjecting our chief executives in an endless cycle to prosecution once they leave office. The founders were very much against that. They were deeply concerned with that. You see that in Hamilton's writings in Federalist 65, 69, and 77. You see it reflected in Madison's concern about newfangled and artificial treasons in Federalist 47. And that is the original meaning of the Constitution.
Do you think we should, it just occurred to me, do you think we should take any cognizance of the fact that when they wrote that, George Washington was the president?
No.
I mean, a very, very strong executive. The Congress
knew that he
was brand
wasn't
new.
president forever.
Everything else was brand new. And
oh my God.
Things have
this is
balanced out. I mean, we've got a strong Congress, we've got a strong judiciary, and we've got a strong president.
I think that if you look at the writings of the founders, they were definitely looking past the presidency of George Washington, obviously an iconic figure, looking past the presidency of George Washington to future presidencies. And they correctly anticipated that the nation might, what they were deeply concerned about was that the nation would devolve into factions. Factionalism did not govern the presidency of George Washington because of his moral authority. However, immediately when you got to Adams and Jefferson, you immediately devolved into factions. They correctly anticipated and were deliberately looking past that presidency.
And Marbury v. Madison was under Jefferson.
A tradition that stood for 234 years until last year when it was shattered by the indictment of President Trump. And if the court has no further questions, we would ask the court to reverse. And if the court rules against us in any respect, we renew our request that the court stay its mandate to allow us to seek further review, both en banc and or Supreme Court review.
Yeah, I told you they're going to go en banc.
Thank you, Your Honor.
So he's got 5 minutes for rebuttal. They're going to go now to
Pierce.
USA. It'll be interesting to see how aggressive they are on the.
Good morning, and may it please the court. Never in our nation's history until this case has a president claimed that immunity from criminal prosecution extends beyond his time in office. The president has a unique constitutional role, but he is not above the law. Separation of powers principles, constitutional text, history, precedent, and other immunity doctrines all point to the conclusion that a former president enjoys no immunity from criminal prosecution. At a minimum, this case, in which the defendant is alleged to have conspired to overturn the results of a presidential election, is not the place to recognize some novel form of criminal immunity. Now, I want to start with jurisdiction, as Judge Childs raised. It is our view that the court has and should entertain both claims before it. With respect to the immunity claim, I think this court's decision in Cisneros 10 years after Midland Asphalt did allude to a type of separation of powers claim that would involving presidential immunity. I think Judge Henderson pointed out the Supreme Court itself has acknowledged that this idea of an explicit guarantee is more of a suggestion than some sort of statutory prescription.
But there's been no cases since then that have actually used that word suggestion, to follow up on that line of thinking.
Within the Supreme Court, I don't believe there have been cases, but certainly this court in Cisneros, as well as in cases also post Midland Asphalt, like Rose, Rostenkowski, and Durenberger have recognized that this type of a separation of powers claim when you're talking about immunity is something for which a collateral order, appellate jurisdiction on a collateral order theory is available.
And there are also other circuits, I think it's 1st, 2nd, and 10th, that keep following that line of thinking with respect to Midland's Asphalt. It requires an explicit constitutional or statutory language that says you cannot be tried.
So two responses. One, I think in cases like Cisneros, this court has spoken otherwise, but nonetheless, I think the only one there is the First Circuit's decision in Joseph, where it was the case of a judge seeking a criminal, raising an immunity defense to a criminal prosecution. As this court acknowledged in both, I believe, Rostenkowski and Durenberger, that's in some tension with, or it didn't acknowledge that, but the case, the court there talked about Claiborne and Hastings, which are 9th Circuit and 11th Circuit cases. I think Judge Easterbrook, in his shock opinion, noted that when it deals with a personal immunity like that, it's different than the kind of transactional immunities that were considered in the 10th and the 2nd Circuit cases. And at the end of the day, I think we do, so sort of a small point of common ground between us and the defendant. We do think that with respect to jurisdiction, there is a little bit of a different inquiry with respect to a president. We don't think that carries over to the merits in the least. And I think United States versus Nixon is sort of the perfect example of that. There, the court said it would be unseemly to hold the president, to require the president to go into contempt. Nonetheless, reaching the merits, of course, rejected President Nixon's absolute executive privilege claim and required that the—
You don't see a distinction on the civil versus criminal context, because the cases I'm referring to are civil, criminal cases.
So I don't, and Rose said as much here when talking about civil and criminal with respect to speech or debate. And again, I mean, I know this Nixon versus Fitzgerald is a civil case, and we strongly disagree that it should be applied here for many of the reasons that Judge Pan set out. But I do think with respect to the immunity, again, given the language in Rose, that would supply basis for this court to entertain the immunity claim.
But
now,
why aren't you taking the position that we should dismiss this appeal because it's interlocutory? Doesn't that advance your interests?
Our interests are twofold. One, as in United States versus Nixon, it is doing justice. And then the second is indeed to move promptly to satisfy and vindicate the public's and the defendant's interest in a prompt resolution of this trial. But doing justice means getting the law right. And it's our view that even if a dismissal on jurisdiction might move this case faster, actually empirically that's hard to know, we just don't think that's the right analysis here on either immunity or the second claim.
So we have a line of cases, including Kramer versus Gates and American Hospital Association versus Azar. It says that we can assume hypothetical statutory jurisdiction and reach the merits of a case. Statutory jurisdiction being distinct from Article 3 jurisdiction, which we could never assume because that implicates the power of the court to act. So if we had discretion to reach the merits versus just dismissing this case under Midland Asphalt, which I think is a strong precedent, which suggests that this appeal is interlocutory and does not fall under the collateral order doctrine. How should we determine how to exercise that jurisdiction about whether or not we should reach the merits?
So I think in the American Hospitals decision, the 2020 decision, the court said the formulation was something like, we're doubtful as to our jurisdiction, but nonetheless, invoking the line of cases you just described, went on to decide the merits. We would urge the courts to do the same here, even if it entertains doubts with respect to the jurisdiction. Yes, hypothetical statutory jurisdiction is available under the law of the circuit. The court should use that to reach the merits.
But doesn't that lead to a hypothetical decision and an advisory opinion?
No, I think so we disagree.
The Supreme Court has said that.
No, I don't think the Supreme Court has said that. I mean, the Steele Co. is kind of the leading Supreme Court decision, and then some courts, including this court, has devised a hypothetical statutory jurisdiction doctrine. Now, if this court were to dismiss for lack of jurisdiction and then say, nonetheless, as an alternative holding, here's how we would come out on the merits. That I think would be improper. That is what I understand the American Oversight Brief to be suggesting at footnote 11 on page 20 of its brief. That I don't think is something the court could do. I understand the hypothetical statutory jurisdiction piece to allow the court to say, you know what, this is hard. There might be arguments on both sides. We think that we assume hypothetical statutory jurisdiction. We move forward. We decide the merits. Now,
let me ask you about Marbury versus Madison. What's your interpretation of its progeny, or even the case itself?
So our interpretation is much closer in line with what I think I heard Judge Pan setting out, and similar to yours. It certainly does not erect a unreviewable power for the presidency. I think the sort of the prime example of that is the Steele-Sheezer case, the Youngstown case. That was President Truman closing the steel mills. That was the court coming in and reviewing that. We see that all the way through to the present. And so it's hard to see any world in which the court just says, we can't intervene here. We do see, I accept the court's, Judge Henderson, the distinction between sort of ministerial and discretionary acts. Compliance with the law is not some sort of discretionary call, right? It is something that I fully endorse or agree with the idea of the paradox of a president, on the one hand, having the Article 2 take care responsibility, and on the other hand, sort of seeing the law as compliance with the law as optional.
Let me switch and ask you, how do we write an opinion that would stop the floodgates? Your predecessors in their OLC opinions recognize that criminal liability would be unavoidably political.
So finally, a good question.
A couple of responses. For one, of course, that was with respect to a sitting president. I think the analysis is extraordinarily different with respect to a former president.
Everyone's a former president.
OLC in that very same, I'm sorry.
Everyone becomes a former president unless they're assassinated.
Being necessarily political.
Well, I think there is a political process which is impeachment, and we can talk about that, but there is a legal process which is decidedly not political. And that is a process which has the kinds of safeguards that a couple of members of the court here have already referred to. We're talking about prosecutors who follow strict codes and who are presumed to act with regularity, grand jurors, pettit jury eventually, and this court sort of standing, Article 3 court standing above it. But I also want to push back a little bit against this idea of a floodgate. At least since the Watergate era, 50 years ago, has there been widespread societal recognition, including by presidents and the executive branch, that a former president is subject to criminal prosecution. And Nixon was not about private conduct. Nixon was about, among other things, using the CIA to try to interfere with an FBI investigation. He then accepts a pardon, understanding that after having resigned, right? So again, I think that also undermines this impeachment first argument. After Nixon, we then see a series of independent and special prosecutors investigating a range of different types of conduct. You saw independent counsel Lawrence Walsh in the Iran-Contra affair. That's an example that the defendant invokes in his reply brief. In chapter 27 of that report, the independent counsel assumes that President Reagan is subject to prosecution and says, but we didn't get there evidentiarily, right? There were not that we thought there was some sort of immunity. And that has continued through to the present. And so this notion that we're all of a sudden going to see a floodgate, I think again, the careful investigations in the Clinton era didn't result in any charges. The fact that this investigation doesn't reflect that we are going to see a sea change of vindictive tit for tat prosecutions in the future. I think it reflects the fundamentally unprecedented nature of the criminal charges here. Never before has there been allegations that a sitting president has, with private individuals and using the levers of power, sought to fundamentally subvert the democratic republic and the electoral system. And frankly, if that kind of fact pattern arises again, I think it would be awfully scary if there weren't some sort of mechanism by which to reach that criminally.
In your brief, you raised some sort of lesser immunity potentially applying. Want to speak to that?
I do. We don't think that's comes into play here. I think the point was in some sort of more challenging cases, it might be that where a president is operating under extraordinary time pressure has to make a very difficult kind of national security type of decision. You know, do I go in and commit this kind of, do we order the drone strike under these circumstances? You know, a president will often have a cadre of lawyers to advise him or her. The lawyers say, Madam President, we'll get you a memo in 2 months. That's not going to be enough in that situation. If there were a drone strike, civilians were killed, that theoretically could be subject to some sort of prosecution as murder. I think that might be the kind of place in which the court would properly recognize some kind of immunity. But that is, of course, nothing like what we've got here. I sort of take the former official's brief discussing the vesting clause to talk about the kind of the nature of charges when they focus on, again, subverting the electoral process. At a minimum, there should be no type of immunity that covers that.
So are you saying it should be a case-by-case balancing in each case, whether there's immunity, or how does this work?
That's inherently political.
So we think that it should just be, as the district court held, finding there is a balancing under Fitzgerald, right? That's our view. You start with this question: what are the burdens against the presidency, and what are the interests to be furthered? I think the answer to that question under Fitzgerald, we think that the burdens that my friend talks about on the other side are overstated. I'm happy to just describe why. We think the interest in the public's interest in on an ongoing criminal prosecution means that there should be an across-the-board rule that a former president is indeed subject to criminal prosecution. What I'm describing in response to Judge Child's questions is, in a particular case, might there be some extraordinary circumstance where a former president could invoke an immunity? Maybe. I don't think the court has to reach that there. I think the court could write an opinion that reserves and says, based on the nature of the allegations, which we take as true, there is no reason to recognize that here. And so I don't think it needs to be a case-by-case analysis, but I think the court can reserve that type of question to the extent it gives one pause about a president in future situations.
To that end, can you answer the question I posed earlier to your opposing counsel about, are we to look at the broader question that was dealt with by Judge Chuckin with respect to presidential immunity, absolute immunity for no criminal prosecution of official acts, versus looking at this indictment and accepting as true the allegations that it brought there? Or both?
So we have a strong preference that the court adopts the former view and looks at the question in the way of, as the district court did, which is to say, based on questions of separation of powers, of constitutional text, history, precedent, is there in fact immunity for a former president? We think the answer to that is no, for of course all of the reasons we put in the brief, and I'm happy to sort of address here.
That's what you mean. Yes,
candidly, I think if the court gets to that second question, there are some hard questions about the nature of official acts. And frankly, as I think Judge Pan's hypothetical described, I mean, what kind of world are we living in if, as I understood my friend on the other side to say here, a president orders his SEAL team to assassinate a political rival and resigns, for example, before an impeachment? Not a criminal act. President sells a pardon, resigns, or is not impeached?
Why would you think that resignation?
I think that is extraordinarily frightening future, and that is the kind of, we're talking about a balancing and a weighing of the interests. I think that should weigh extraordinarily heavily in the court's consideration.
Would preclude impeachment. Why would resignation
preclude the effect of Blasingame? What is it? How does it either bind us? How is it persuasive for us?
So I think it formally has no application at all, because of course, very early on in the opinion, the court says we're not dealing with any questions of immunity in the criminal context. I tend to agree with my friend on the other side that in many respects, it does reinforce the nature of the Fitzgerald civil outer perimeter standard. It says you don't look at intent or you don't look at purpose. Context plays a more important role than often the content of communications. I think that the significant change, of course, is the acknowledgement of the looking at a president, whether that president is acting in his or her role as office seeker or office holder. But again, to go back to my response to Judge Childs's question, although that would change the nature of whether may change the nature of whether certain things are or are not official acts in the indictment, we just think that's entirely the wrong paradigm to use. We think under Fitzgerald, in fact, that would be inconsistent with Fitzgerald's reasoning, and also just irreconcilable with the nature of how criminal law works. Correct. I mean, to say that we're not going to take account of motive or intent, there are plenty of acts that every day. I mean, for example, if I were to encourage someone not to testify at trial because I wanted to go on a hike with that person, it's not a crime. If I were to encourage someone not to go on a hike because their testimony at trial, encourage them to skip their trial testimony because their testimony was going to incriminate me. It's the same underlying act. And now when you map that on to the presidential context, you come up with some of the frightening hypotheticals where as long as something is plausibly official, even if it involves assassinating a prominent critic or a business rival, that would seem to then be exempt potentially from criminal prosecution. We certainly wouldn't concede that if that's the world we need to live in. I think we would advance plenty of arguments below, but we really, but those arguments themselves would create satellite litigation that are an additional reason not to go down this route.
But looking and thinking about your answer about potentially not looking at motive and intent, when there is a criminal prosecution, that mens rea and that intent is part of the actual statute charged criminally.
Yes, precisely. And that's why it wouldn't make sense to then come in and use this non-motive intent. As I understand how Fitzgerald outer perimeter standard might work, it could say those types of official acts, official conduct, that is something from which the president is immune. You don't ever get to that second question of, well, did that person act then with mens rea? Can we prove it beyond a reasonable doubt? Because it is at least under a theory where it's not available at trial, then there's no way to reach that conduct.
When we're looking at this indictment, though, back to Judge Henderson's question about the use of blasting game, some of the acts are same or similar, and there was direct discussion of it in that opinion as determining whether it was office seeker versus office holder. So do we use blasting game at least for that?
So if this court decides the case the way the district court did, then I don't think blasting game has any role to play at all, because there is no question of whether, was this act official or were these sets of allegations official? The question is, based on a Fitzgerald analysis and history, precedent, et cetera, is there any quantum of immunity for a former president? We think the answer to that question is no. There's no reason, as the district court also found, to turn to the indictment and consider this outer perimeter, this civil outer perimeter standard.
How about if you don't decide it the way the district court did?
If you don't, I suppose a lot would
on the blasting game.
So there are a lot of different ways this court could not decide it that way. I think to pick up on my response to Judge Childs, we certainly stand by our view in the brief that some substantial number of allegations would fall outside of an outer perimeter, and that I think is enough to affirm. I think either parties are urging the court at that point to then send, of course, the case back to the district court. I think that then would create a series of challenging questions that I mentioned earlier. What are the evidentiary theories under which that evidence could potentially come in? But it would be our strong view, and we would want, if the court followed that route, which we urge the court not to make clear that immunity is an on-off switch, right? This is the immunity appeal. If the court says we affirm, we send it back, there's no immunity, then other things become evidentiary questions or questions really of jury instructions, in which any appeal is then an appeal from a final judgment, if any final judgment.
And the immunity defense is never lost.
Well, I don't think it's immunity at that point. I think this court will, in what I've just described, will have said there is no immunity. There may be some types of other challenges as evidence comes in at trial. But again, I think that would lead to this extraordinarily complicated litigation that is not the top line reason, but certainly among the reasons why the court should not go down that path.
Since President Trump concedes that a president can be criminally prosecuted under some circumstances,
That's not what he said.
That that is true only if he is first impeached and convicted by Congress.
It's a condition
Do you
precedent.
agree that this appeal largely boils down to whether he's correct in his interpretation of the impeachment judgment clause? That is, if he's correct that the impeachment judgment clause includes this impeachment first rule, then he wins. And if he's wrong, if we think the impeachment judgment clause does not contain an impeachment first rule, then he loses.
So I think that's basically right. I mean, the defendant's theory over the course of this litigation has evolved a bit. And I think now before this court, I understand the argument to be principally sort of the principal submission to be, as you've just described, this, what we call in our brief, the condition precedent argument.
Yeah.
That there is only liability, criminal liability for a former president if that president has been impeached.
No one said condition precedent.
And that is wrong for textual, structural, historical reasons, and a host of practical ones, one of which I'll start with again to just amplify the point. It would mean that if a former president engages in assassination, selling pardons, these kinds of things, and then isn't impeached and convicted, there is no accountability for that
Why is that a problem?
That is frightening. Now, to go back to some of the textual and historical and structural, my friend on the other side sort of suggests this is what the founders were talking about and this is what they were worried about. I think that's entirely an inaccurate representation of the founding era history. There's basically no discussion of the impeachment judgment clause, which I take the defendant's principled textual argument to be. What the impeachment judgment clause did was two things, as the district court described, right? It constrained the sanctions that Congress could place on an impeached and convicted officer, not only a president, any kind of officer, to removal or disqualification. And then it made clear that that impeachment did not impose some sort of preclusive bar on subsequent criminal prosecution. You would think that if there was this kind of impeachment first requirement, impeachment and conviction first, you might actually find something somewhere in the sources, the framing, the convention in Philadelphia, the ratification discussions.
After conviction.
History. There was nothing of that. We've cited certain things in our brief from James Wilson, from Edmund Pendleton, from Representative Dana that say this. Justice Story. I don't hear the defendant to offer anything other than, well, Hamilton. All that Hamilton was describing was the undisputed point here that a sitting president can't be subject to criminal prosecution until that sitting president is no longer in office, whether the removal from office is through impeachment and conviction or simply the end of the term. Now, one structural point as well that I just want to quickly make, the district court made this, which is if this rule were right, that would if the condition precedent rule were correct, it would pose significant separation of powers problem of its own. It would basically mean that the executive branch would only be able to prosecute someone if Congress had acted. And there are all sorts of reasons why, of course, Congress won't act. For one, they've never believed that it was required, and also
they will if the court says that's a prerequisite.
In certain instances, they may decide that they don't have jurisdiction. Many of the members of Congress seem to hold that view with respect to the defendant's second impeachment.
These are really weak counters as to why it's a problem as to have a condition.
Thank you very much.
Those are very weak arguments. If this court were to decide that it is a condition precedent, then Congress will know that, yeah, you have to impeach him and convict him if you want to be able to go after him criminally.
Thank you, Your Honor. And in my limited time remaining, I just want to make 3 points to the court in response to the opposing counsel's argument there. One is that the opposing counsel used the phrase above the law, saying that an immunity doctrine for criminal immunity would place the president above the law. I would just direct the court's attention to what the Supreme Court said in Nixon against Fitzgerald in the context of civil immunity. They described the allegation that immunity sets the official above the law as, quote, rhetorically chilling, but wholly unjustified. The U.S. Constitution, the separation of powers, the executive vesting clause, the impeachment judgment clause, these are the foundational and fundamental law of our country, and the president's immunity is determined on that. So that is more rhetoric than reality, is what the Supreme Court said in Nixon against Fitzgerald. I'd also point out that when it comes to the question of whether or not the indictment alleges solely official acts, the indictment does not allege that President Trump did anything wrong after he left office. So it focuses solely on acts that he took while he was in office. And that's a telling indication that we're dealing with official acts here. And then finally, I would address Judge Henderson's your question about the floodgates. And I tie that to what my opposing counsel said about a so-called frightening future. The frightening future that he alleges, where presidents are very, very seldom, if ever, prosecuted because they have to be impeached and convicted first, is the one we've lived under for the last 235 years. That's not a frightening future. That's our republic.
That's great.
What he is forecasting is a situation where the floodgates will be opened. We are in a situation where we have the prosecution of the chief political opponent who's winning in every poll. Presidential election upcoming next year and is being prosecuted by the administration that he's seeking to replace. That is the frightening future. That is tailor-made to launch cycles of recrimination that will shake our republic for the future.
If you have the impeachment judgment clause, as you indicate impeachment, then conviction, but then the president either resigns, is removed, and then later on is prosecuted for a different crime. Can that happen, or is there immunity there?
I'm not sure I understand the hypothetical. Could you say it again? I apologize.
Just indicating that if you're resting on that there must be impeachment and conviction, and it's for one set of crimes, but then later on the president either is removed from office.
That's a great
or
question.
Resigns.
That's a solid question.
And later on, there's a prosecution for something different. Is there immunity for that later crime?
Yes, I think that's the better reason. Obviously, it's not presented in this case because we have a close match between the conduct, the underlying conduct or transaction occurrence that's alleged in the articles of impeachment, of which there was an acquittal, right? Which is the strongest case for double jeopardy, and between the facts alleged in the indictment. But if there were like an unrelated prosecution,
you just made a statement about he's only being prosecuted for crimes while in office. And so that's why I'm asking about leaving office and then thereafter being prosecuted for something different.
To be under the plain text of the Constitution, the best reading would be he has to be impeached and convicted for the thing that he subsequently prosecuted. So if he were impeached, convicted, and removed from office, and they charge him with another official act that was unrelated to the impeachment, I think that what Chief Justice Marshall says in Marbury would still govern. I think that's obviously it's not presented in this case. The court doesn't have to decide it, but that'd be my answer.
So I just want to confirm your position is if President Trump had been convicted after his impeachment trial on incitement of insurrection, if he'd been convicted, then this prosecution would be entirely proper.
Which I would say that if he were impeached and convicted for the same and similar conduct, then that would authorize a subsequent prosecution. Obviously, we have many other issues with this prosecution.
Is that a yes?
So I do.
Because I think you said in your brief that impeachment for incitement of insurrection is based on the same or related conduct as that which is in the indictment.
Yes, I agree with that.
So if he had been convicted by the Senate, then this prosecution would be entirely proper.
Yes.
Well, I would not phrase it that way because there's lots of other problems with this prosecution that we've raised in extensive pleadings to the district court. He could be prosecuted
under the impeachment judgment clause. If he had been convicted by the Senate when he was impeached for incitement of insurrection
then immunity
on
would not
same
be
or related conduct as what's in the indictment, then this prosecution would be properly brought.
There would not be immunity.
There's a prosecution could be properly brought. This prosecution, which has tons of other problems. I just want to be very clear about that.
Just say there would be no immunity.
This prosecution is.
All right, let me try one more time.
Just
under your interpretation of the impeachment judgment clause, if President Trump had been convicted when he was previously impeached on same or related conduct as that which is in this indictment, the government could properly prosecute him for that same or related conduct. Yes or no?
Potentially, provided they qualified with all kinds of other legal doctrines that are violated in this case. So I admit that a prosecution.
I'm asking you under your interpretation of the impeachment judgment clause, is that proper? Is that allowed?
And I stand on my prior answer. I think we're agreeing.
I understand there might be other reasons why you would challenge this prosecution. I'm saying based on your interpretation of the clause, this prosecution would be properly brought.
If Again, I would not say this prosecution. Be very clear about that.
But it's a prosecution based on
Just
same
give
or
to her
related
that there be
conduct.
no immunity, presidential
This
immunity.
prosecution, which has
What
many
you
other
asking
issues related to it, what I would say is that the impeachment judgment clause authorizes the prosecution of a president who's been impeached and convicted by the Senate, which President Trump
All right,
has
we'll
not.
make it a hypothetical. Say a president was impeached and convicted on a charge of incitement of insurrection that is under the same allegations as a criminal indictment. He's convicted. Then the government could bring a prosecution for the same or related conduct, correct?
Don't disagree with that.
Okay.
That's it correctly.
And then that means that the conduct that's same or related, even if it's official, he could be prosecuted for it, correct?
You're convicted.
Correct. Okay, thank you.
But my question goes to after the fact, and the reason I say that, even though you're challenging that these actions are only occurring while president, the district court's decision was that there is no presidential immunity from prosecution for official acts. It doesn't put a time frame in there. And so that's why I'm going to beyond your investigation, your prosecution might not come until later.
Okay.
After the president has left office. So are you telling us that we are limited to a time frame in answering this question?
No.
I think the time frame is set forth by Chief Justice Marshall against Madison when he says never examinable by the courts. So unless there is that one gatekeeping incident that has to occur, which is impeachment and conviction, the official acts, the court has no jurisdiction to review them under the separation of powers and the executive vesting clause.
But that also assumes that an impeachment proceeding occurred. If there is not one, because we discussed earlier that not all officials go through that process.
Absolutely.
That's
And
a
they couldn't be
judgment call as to
criminally
whether that
convicted.
process would even be brought.
Oh
I
my
would say there are
God.
two arguments that reinforce each other. So if there's no impeachment ever and no conviction, then the official acts are immune, period. Further, the impeachment judgment clause incorporates a doctrine of double jeopardy that prohibits it, especially in the case of acquittal. So those are reinforcing doctrines that are set forth in the Constitution. If there are no further questions, we'd ask the court to reverse.
All right, thank you.
Wow. Are they done? It sounds like they might be done. It looks like they're done. Okay. So I'm going to give you my thoughts and address some questions and some rumble rants, but I'm just going to give you my preliminary thoughts here as to what it is that we just saw. Okay. The nature of the questions that are being asked, it certainly looks as if they're done, but I'm leaving the volume playing. So if we hear anything from the court, which I don't anticipate that we will, in that case, I'll just reopen that window so you all can be aware as to what's happening. That's not just some background on my computer. The nature of the questions that we just heard, based on how Trump's attorneys were being questioned versus how the United States was being questioned, are indicative as to the mindset of these judges. I'm expecting this to be a 3-0 ruling against Trump. I'm expecting he's going to lose this case, at least at this stage. As to what's going to happen when it goes en banc, or what's going to happen when it goes to the Supreme Court, which there's certainly going to be a petition for it to go to the Supreme Court, we don't know. But I'll tell you that we can tell from the nature of the questions, they were being very, very aggressive far more aggressive with Trump's attorneys than they were with the United States. That's often, not always, but in the vast majority of cases, that is indicative of what they're the mindset that the judges are walking in with. That here are the reasons that we think your position sucks, as opposed to like sometimes the nature of the questions they're asking to the United States was, well, what should we do in this circumstance? It's sort of almost like help guide us as to how you want us to write our opinion. When they're framing it in that way, it's almost as if they're saying, we like your case and we like your position and we want you to, help frame the argument as you think we should write it. And that was the nature and tone as to what we just saw right now. I'd be very surprised if if Trump wins this appeal at this stage, based on the nature of the questions that we saw. I'll tell you this much. Some of the hypotheticals they were throwing out there, I wish that Trump's attorney would have taken a more assertive position just in latching into what his adversary ultimately said it boils down to is this a condition precedent? Is the impeachment clause, which says that, That video just closed. So we're
Stand,
there.
please.
That's a different case now. Okay, so that case, that oral argument is over. So that rooting it in the impeachment clause is essentially and calling the impeachment clause a condition precedent. And I'm going to pull up the impeachment clause, the language of the impeachment clause, so we can look at it together. That fulfillment of the conditions of impeachment, i.e., that he gets convicted by the Senate prior to there being a capacity for him to face any sort of civil or criminal charges, that calling it a condition precedent is fine. And he seemed to be very reluctant to call it that. His adversary ultimately called it that. Judge Pan, I'm fairly certain it was Judge Pan, based on the voices of each of the parties who were asking questions. Judge Pan seemed to be asking, if we find, doesn't this ultimately all turn on that one issue as to whether or not this is a condition, the impeachment conviction of impeachment is a condition precedent to go after a president for any acts that are in his official capacity. So that is the seminal issue. And there's nothing wrong with rooting and saying, yeah, this is where we're drawing the line. This is it. Everything else he was saying was supporting that conclusion. Everything else that Sauer, Trump's attorney, was saying supported that. So it's very strange that he seemed to shy away from that or avoid using that phrase, because it just sort of falls off all these other questions. Some of the questions that he's being asked, well, what if he hires a member of SEAL Team 6 to take out his political adversary and he never gets impeached? Well, that's okay. Then he should get impeached. I also would have countered what the hypotheticals that the United States was presenting of, like, well, he can then shoot up Congress and resign and never be convicted. It's like, no one says that resignation would preclude impeachment. Why would anyone think that? Why would anyone think that if he resigns and tries to sidestep liability via resignation, that would be operable to help protect him with the shield of presidential immunity? That makes no sense. That's not implied anywhere in the Constitution. So why would anyone think that that's actually that's a relevant thing? Try and pull up here the impeachment clause. And I'm going to get to some of the Rumble rants and also to some remaining chats and some of the chats that came up earlier, like very early on, like this question here. There's some questions that came up which I think are important for me. So here's the key clause, and it's so difficult. You have to twist yourself into a pretzel to ignore this. This is clause 7 of section 3. So this is the language. Judgment in cases of impeachment shall not extend further than to removal from office. Meaning, when you impeach someone, if he's convicted, the only punishment you give him, you can't send him to jail, can't do anything. If he's impeached, the only thing you can do to him is remove him from office. That's what would come, is that he no longer holds his office and he'd be disqualified to hold and enjoy any office of honor, trust, or profit under the United States. Okay, let's just pause there for a moment. So what's the punishment? What's the result of a conviction? The only punishment you can have is you can't throw him in jail, you can't execute him. The only thing you can do is remove him from office and stop him from holding office in the future. And the final sentence here, though, that says, but the party convicted, meaning if convicted, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So Trump's argument here is that if he's indicted, the party convicted at the Senate level, that person can be held liable and subject to indictment, trial, judgment, and punishment like any other person. So that sounds like, anyone reading this would think, this sounds like it's it's a negative condition, meaning you can infer from this that, well, what happens if he's not convicted? If he's not convicted, then he cannot face any sort of judgment and punishment. If the Senate refuses to convict him for the action, then no, he faces no further punishment. I like the fact that he stood strong when he was asked, well, what if he's impeached for series of facts A, and for which constitute a crime, and now you want to go after him for a different series of acts that he took while president? Could he be prosecuted for that? And I like the fact that he said, no, you can't. You can't do that. So I think that that's consistent with the reading of this of this clause, of clause 7, that there has to be an impeachment. It's a condition precedent. The phrase condition precedent means that before you can do X, this condition must be satisfied. It has to precede it. That's why it's condition precedent. It has to precede you being able to do all this other stuff. So what's all the other stuff? That he's going to be tried criminally. What's the condition that must happen? First, what must happen is he has to be convicted in the Senate in an impeachment proceeding. That's the only way it can happen. That's this seems to be very, very plain. You have to twist yourself into a pretzel to ignore this, and these judges seem very happy to contort themselves as much as they like. Now, the question comes down, what the Supreme Court has said is that this isn't talking for anything he does. It has to be something that is presidential. And one of the things they were talking about is, well, it's part of his presidential acts. And then they were talking about, well, is there a difference between ministerial versus discretionary, meaning some that he's required to do versus those that he chooses to do? Meaning it's part of his presidential acts, but it's not listed in the Constitution. You have to do this. And these acts sort of fall under discretionary. What do I mean by discretionary? Why would these acts relate to discretionary? Well, if you look at the functions of the president, it doesn't say anywhere there that it's his duty to ensure that elections are run properly. It doesn't say that anywhere. That's not part of his official charges. Now, it seems to fall under the ambit of things that he would tend to cover, as far as making sure that the laws of the Constitution are being faithfully executed, and it sort of falls in that sort of thing. But to say that it's his duty to ensure that the election of 2020, or some election that's happening in a state, is being run that leads to the final outcome of the federal elections in 2020, that's part of his that's his official you must do this. You have to do this. It's your job as president to do that. That doesn't seem to flow from a typical reading of the Constitution. You could try to read it in there, but it doesn't tend to really flow from it. But it does seem discretionary that because he's the chief of the executive branch, that for him to oversee and make sure that the laws are being faithfully carried out, that it falls within there. So it's not really potentially ministerial that you must do it, but it's more of a discretionary type of thing. And that's one of the things they were trying to parse out during these oral arguments, is to figure out whether or not this immunity, if you're going to say that his immunity flows to things that he must do, that makes sense. But what are things that he chooses to do but is not necessarily obligated to do? Should it flow there? And the logical conclusion is, yeah, I mean, the whole point is that we should be enabling presidents to be an effective leader and not sitting there looking over their shoulder all the time saying, am I going to have some political hack prosecutor come after me 10 minutes after I leave office, trying to have me hanged for some decision I'm making today? It sounds asinine. It sounds ridiculous to say that should be the case. And it seems as if they were very, very very hung up on some weird issues during the course of these arguments, where the judge was basically they're implying that SEAL Team 6 question. Oh my gosh, I'm sitting there. Are you kidding me? But the nature of the softball questions that the United States was getting, it just leads us to believe it certainly leads, I can't see us, well, who's us. It leads me to believe chances are very high, that there's going to be a written decision against Trump and that he's going to lose at this stage. I'd be very surprised if he does not. I'd be really surprised if the decision of the district court is not affirmed, if they reverse the district court. Now, an interesting question they talked about, another interesting question they talked about is, let's say we believe your take here. This is a question that who was it? It was that Judge Henderson, the older judge who was 80 years old, was asking him. Let's say we go along with your argument that there is a immunity that the president enjoys for things that are within his official acts. Well, there's a lot of different acts that are asserted here. Some of them may be more official. Some of them may be not part of his official duties. Some of them you might even admit that, hey, that's not part of his official duties. His speech at the Ellipse, is that part of his official duties that this is part of you trying to administer? It's difficult to that's more of a stretch than him talking with people about ensuring that the election was run properly, like pushing them to go protest peacefully and patriotically. That's far less of like, yeah, you as president have a duty to ensure that the public is peacefully protesting. That doesn't seem to fit as squarely as you have a duty to ensure the election is run properly. Now, you can draw a stretch to say that that's part of his efforts to ensure it's been done properly, but that's another degree of separation from his powers than something that's far more overt, far more obviously him carrying out his functions as president. So what the judge was asking was, so are we supposed to remand it to the district court? Because the district court is where you have findings of fact. And when you have those findings of fact that we want to try and assess of all the acts that are asserted here, let's start classifying. Assuming there's immunity for the things that fall under this umbrella, whatever that and wherever it extends to, whether it's in discretionary or in ministerial, or whether it's in acts as a private citizen versus acts as a public figure, depending on however we classify it. Let's assume that we do have a classification that it will extend to these types of acts, but not those types of acts. Now we're looking at an indictment that's 170 paragraphs long, and it asserts tons of acts, tons and tons and tons and tons of acts. Some of them might fall under this. Some of them might fall under that. So do we need to remand this down to the trial court for them to start parsing out paragraph by paragraph these acts that you're claiming fall under category A that have immunity, and these acts that are category B that do not have immunity, and then in theory, all stuff that has immunity, toss those in the garbage. All the stuff that doesn't have immunity, now let's look at those as in the aggregate and see, is there enough here that those are the only things he could be prosecuted for? And that's something that Sauer, for counsel for Trump, seemed to admit that that's a logical flow. That's a logical approach for this court to take, that the defendant would recognize that if you were to take that approach, that's a fair way to assess this. And I think that was a wise move on his part. I think strategically it was a wise move on his part, because it shows that he's not just saying, well, once you knock out some of them, they all have to be knocked out. That just sounds like it sounds less interested in justice and more interested in just anything I can do to get my guy off. When you're trying to convince a panel of judges or an individual judge to embrace your position, the more reasonably you can present your arguments, the more likely you are to have success in that endeavor. So when he's saying, hey, look, I understand, I'm not saying he has immunity from anything. Well, what happened between Clinton and his hordes of girlfriends, that if there was a crime that was committed there while he was president, that wouldn't extend to there wouldn't be immunity there. And in theory, actions that President Trump took while as president that are of purely personal nature, he could be charged and we wouldn't care about the impeachment clause. So in that context, when he gives in and says, yeah, so how do we know each act that is being alleged, how do we know how to classify it? The court would have to go act by act and actually start parsing that out. That seems like a fair way to assess the legitimacy and maybe see after it all comes together, is there still enough left? Is there still enough left that if he was found guilty on it, that he would be charged? Now, there's a bunch of questions that came up here that I want to address. Bunch of questions that I feel I'm going to start with the Rumble rants here. So first Rumble rant was from Snorkel Boop saying, we do have political roles that have absolute immunity for prosecution. Foreign diplomats seem to be a good analogy. They're protected by their office. Yeah, that's true. That's true. Southeast says, under their theory, every government worker could be convicted of sedition if they rule against the Constitution. Every government worker, well, when you say rule against the Constitution, you mean act against the Constitution. I didn't really take that from what they were saying. I mean, I guess sedition, there's no claim of sedition here. You have to, I wouldn't phrase it quite that way. Southie also says Washington was a seditious traitor and turncoat that led the greatest revolution of all time. Just saying. Yeah, that's when they were talking about, what a stupid question. Would you say that perhaps the reason that they gave so much authority and such respect for the office is because Washington was the president at the time? No. Who the hell would even ask such a question? What an asinine question that they didn't realize the significance of the fact that they're creating a country that they were anticipating would last for many generations, if not in perpetuity. They're trying to set something up that would work in perpetuity. The reason they have amendments rather than saying these are edicts forever is because they recognize that, hey, this country is going to be here, God willing, for a long time, and there needs to be a certain flexibility based on change of culture over the next several centuries. So that's why they can be amended. That's why they call them that they're amendable. They're not carved in stone forever, but they can be amended if there's enough of a backing from the country to amend it. That reflects a mindset of our founders that no, we're not sitting here trying to figure out what to do based on who happens to be sitting in the White House today. So it's ridiculous. It's such a stupid question. I was just like, I'm like, that's really. That's your best? That's the best and brightest? Unbelievable. Unbelievable. That was an abortion. That was just an abortion. All right. Jared Collins asked this question at the gate. He said, Joe, do you think that lawyers with unpleasant speaking voices, no one in particular, of course, yeah, I know what you're saying, would have a harder time in jury cases? I think I would tune out after a while. You would have to assume on a jury case, it is likely to be off-putting. It is likely to be off-putting. Like it just sort of, I think that when the jury case goes on for a while, you start becoming numb. You stop hearing how grating it is. When I first heard RFK, it was a similar voice to Sauer. When I first heard him, I was like, I can't listen to this guy. But now when I listen to him, I barely even notice it. So I think a lengthier jury case, it probably would be less impactful. In a shorter jury case, where they don't have the jury has less time to acclimate to the voice, it certainly may. The idea is you want the jury to be paying attention to you, and if they just get revolted from the sound of your voice, you got to figure it's going to have some sort of impact. Less so, you would think less so when it's a bench trial, but a jury, yeah. Now, I thought this was a good question, and it's a good legal question that I just wanted to answer and give you perspective as to why I think the court is correct in this. The panel of judges, I think, is correct. Why do they assume the allegations are true? Doesn't that go against the presumption of innocence? Sorry, I came in late. Nothing wrong with you. It's not your lateness that led to this question. This is a lot of people, I think, would agree with you, and I'll tell you why they are mistaken, and why the judges are correct to look at this with an assumption that the allegations are true. There's a concept in general that in order to find fairness to both sides, that if an appellate court is going to come in here and say, before there's even any finding of fact, there's been no trial, no evidence presented, no nothing, that we're going to get rid of this case and say this case is no good and cannot go forward. In order to determine that accurately, you have to start with an assumption of, let's say the case that the party that would lose it would succeed in managing to prove every single thing that they are claiming in their allegations, whether it's in a civil case, it could be from the plaintiff or defense. Over here, it's in the indictment. You sort of want to see, well, let's say that everything they're saying, they're making all these allegations. Are all they're going to prove true? Hell, we don't know. They may not. There's no way to know. But if you want us to get rid of this case without even giving them a chance to prove it, that means that there has to be no set of circumstances where they could possibly win. If you're looking for a case where there's no set of circumstances that the state could win, you have to start with an assumption of, well, let's see if the state managed to prove all of these different things, would they win or would they still lose? So if you want to have something dismissed, you always have to start with an assumption that the party who would be losing, that they still would lose if all of their allegations were held true. Does that mean that they're sitting here saying these allegations are true? No, but they're saying you want us to dismiss this case. If you want us to dismiss this case, we have to pretend and prepare for a situation where they manage to prove every single allegation and then see if they prove every single allegation, would they have a chance of winning or not? Does that manage to form a cognizable claim on their behalf or not? So that's why you're right that there's a presumption of innocence, but that presumption of innocence is when we're at the stage of trying to make a finding of fact, trying to figure out, is this fact that you're claiming, is it true, is it false? We're going to presume you're innocent. I'm presuming you're innocent. So whichever way is going to help presume you're innocent, when we're trying to figure out, did this happen, did that not happen, that's where the presumption of innocence attaches, and that's where that presumption is most significant. But at this stage, when they're not trying to figure out which facts are true, which facts are not true, they're just trying to figure out, should we allow this case to survive? You must start from a position of, let's assume that if this were to happen and they were to prove everything that they're claiming, would they still have a good case? And if we say that, and even in that case, they still would lose, that's where it would be dismissible. Otherwise, it would not be dismissible. So that's why they had to start that presumption. Attorneys to the people who don't practice law, it does sound counterintuitive based on what we tend to understand about presumption of innocence. But to attorneys, this is something that it may. It's a logical starting point because we're trying to deprive the state of an opportunity to prove its case. When you're looking to dismiss it, you're saying, I don't want the case to have the state to even have a chance to present their case. Well, in that case, let's say if they proved their case, where would we be? Yeah, I agreed with this, Larry. I forgot to take that down before. The second impeachment trial would have been moot because Senate trial happened after 1/20/21 and Senate trials needed to remove from office and he was out of office. You're respectfully, B-Man, you're mistaken. Because when we look at the impeachment clause, that's not all it does. That's not all it does. It also would serve as a disqualification to hold and enjoy any office or honor. Now, there are disagreements as to whether or not one of the things that the court brought up was that Trump stated when he was opposing impeachment, he's like, you can't impeach me, I'm out of office. So like, he's saying, well, since I'm not in office, I can't be impeached anymore. Now you're saying, well, if I'm not impeached, I can't be criminally tried. So it does come across like he's trying to chew his apple at both. He's trying to burn this candle at both ends. That when he's sitting in impeachment, he's like, you can't impeach me, it's too late. Well, by that logic, if he were to do all sorts of, if that's true, and now this is also true, that he has to be convicted at an impeachment before he can be criminally charged, that would lead to a conclusion that if on the day before he leaves office, he were to do all sorts of terribly criminal acts that are within the ambit of his presidency, that could fall in under the protections of immunity, do all sorts of terrible, terrible acts that any Congress would impeach him, but they don't have time to impeach him. And then since it's after the presidency, now you can impeach him. And then he says, well, because I'm not impeached, you can't convict me. That seems to give him carte blanche, do whatever the hell he wants to, as long as he can give it a colorable perspective of like, I was acting as president. So that is sort of so that's why the only logical way to read that is to imply that yes, even that impeachment can happen after he leaves office. And the logical basis to have such a thing is not to say he's being removed from office, but to have him disqualified in the future from enjoying any office or honor. So is the View filling in for the that's pretty funny. First order thinkers, judge worried about murder, can't see that if Congress doesn't impeach, they'll be booted at next election. Yeah, I mean, I don't know if that would actually happen. It probably depends on the individual congressmen or congresswoman that we're talking about here. But, and here's the thing, they seem to really shield themselves behind the whole political nature of things and saying, well, prosecutions are apolitical. And here it's such a disingenuous statement. And the reason it's such a disingenuous statement is because on the one hand, Jack Smith is saying, we have to get this done now. We have to get this done now. Why? Because it's obviously political. And then you're going to say, we're free of any politics. We're free of any politics. The one is belied by the other. If you're here, by the way, and you're new, you just found me, I'm going to urge you, if you can like and subscribe, I would appreciate it. Whether you're on YouTube or you're on Rumble, if you're enjoying the commentary, I would appreciate if you could please like and subscribe. And you can find me on Locals at goodlogic.locals.com. That's goodlogic.locals.com, where I have a lot of added content, and I also give notices as to where you can find me, because even if you hit subscribe, you're likely to not get many notifications from YouTube about me. Trump's lawyer erred by not highlighting this. I'm not sure when you're saying this. That was 13 minutes ago, but probably the condition precedent is what you're referring to, I assume. Squabob says, I think Joe has it correct. Not exactly a kangaroo court, but a rubber stamp and rhetorical anti-Trumpism. That's how I would phrase it. That's how it seemed as if they were desperate to come up with all these different bases to pretty much ignore the impeachment clause and try to find some way. It's like, no, we don't agree with your reading. I mean, and they're ignoring Marbury v. Madison, saying the whole point is, why do we have this? Why do we have this? The idea is we don't want to have presidents facing some sort of threat of, well, your political enemies hate you. They're going to try and throw you in jail. They're going to try and have you executed after you leave office. And it's such a ridiculous claim that went completely unchallenged by the courts, where he's talking, where he's basically, first of all, the claim that if he resigns, then he would insulate himself is ridiculous. But this idea that they're acting completely apolitically, I mean, or that this would not create some sort of problem in the future. The whole purpose of the impeachment clause, the whole purpose, why would we have such a high hurdle? Why would the founders put in this really strong protection based on the reading that's being applied by Trump, that I believe is correct, that it's a conditioned precedent? He has to be convicted by the Senate before he can have such wide authority. Why would they do that? The reason they would do that is because they want him to act free. They want him to be unfettered when he's acting as president, without fear that he's going to face any sort of criminal charges, because you can't lead that way. And when you have Judge Juliana Michelle Childs saying, well, that sounds inconsistent with the other things, which say he has to conduct his role faithfully. So you're reading one clause that it's such a childish take. Judge Childs was basically giving a childish take as far as understanding as to what the whole purpose of why you would have such a high hurdle. That you can compare his duty to act and execute his office faithfully, and compare if he's violating that, why should we be worried about this? I mean, it was just, I was like, are you kidding? Really? The idea is that we need to have a president who can lead without fear that he's going to be criminally prosecuted. So, and that we has to be some set of scenario, some set of facts where if this guy is really crazy, in that case, he can be punished. And we would assume that if he acts really like a crazy person, that he'll be convicted by the Senate. That they're not going to be so partisan that if the guy acts like a raving lunatic, that the Senate's going to be like, well, we're still not impeaching him. There's an assumption that there's going to be some level of political hackery, but not that level where if the guy is really crazy. And the point is that once he reaches that level of crazy, yeah, go after him criminally. But until that happens, we want to give him a broad range of ways to act so that he doesn't have to sit there looking over his shoulder all the time. It's the only way you can lead. It doesn't matter whether it's Republican or a Democrat. It's the only way anyone can lead. Couldn't this lead to extradition countries indicting our presidents for basically anything that country doesn't like? I'm not sure why this would lead to that. In theory, they could do it anyway. They don't have to follow our Constitution. So I don't think that this finding would have much of an I can't off the top of my head see why this finding would have an impact on how a foreign country would act in treating our presidents, to be fair. The impeachment conviction requirement seems to me to interject the will of the people through their elected reps before immunity can be stripped from a president to avoid political cases. That's precisely correct. Because there's an assumption. The founders had an assumption that they're going to try and have political retribution. That's why you would put this protection in there. I assume that the other party hates you and that they're going to want to come after you. How do we stop that from happening is if we create a conditioned precedent that you have to be convicted by the Senate at an impeachment hearing. That's the only way to protect the president. Otherwise, invariably, that will happen. I wish he would have hit on that much harder. I felt like he sort of, they talked about in their papers, but that this is the assumption of the founders, that you're going to be subject to criminal prosecution unless we put a protection in there. And this is fairly express, that you cannot have it. It's only upon conviction that he's subject to judgment. Why would they put that in there? Why would you put that in there at all? I'm trying to think. I was actually looking this up recently, and I was trying to figure out where the presumption of innocence came from. I don't know. Oh, I'm glad I helped. How long was the whole hearing? The whole hearing was, I don't know, roughly an hour and a quarter to an hour and a half. It wasn't crazy long at all. All right. If you're still here, I'm going to urge you to make sure you like and subscribe. Tonight, I'm going to be streaming. Oh, Jonathan asked, do you think judges in general have too much power? It seems like it to me. Don't know any way to fix that, though. Well, because of Marbury v. Madison, arguably they do. Arguably they do. Yeah. Anyway. So tonight, I'll be streaming tonight at 10 p.m. Also at 4 p.m. I plan on being on Sitch and Adam. But you want to find these different links, I share with them on Locals, and I will share that with you guys later. As there are more developments here, I plan on covering this case and all the other Trump indictments with a very, very close eye. You can follow me on Trump Trial, which I'm not streaming to right now, but that's another channel that I have down in the links below. If you follow me there, I would be obliged. On Locals, you can find me on Twitter at The Following Pro. I'm all over. But I'm not easy to find, so click the links, you'll find me. I thank you so much for joining me. I will see you all later. I think I covered everything I need to cover. I did. We're good. Okay. Thank you so much for joining me. I'll see you all later. Take care of yourselves. And as always, my friends, I say, Godspeed.